me see here.
Thank you.
Do we need more chairs? We might.
Yes.
Yes? Oh, you got a spot for it? Yeah. Thank you. Yes, you can sit back. Hey, how you doing? Yes, there was somebody, they were having no chair. Okay, we'll move the chair. I gotta take that one or, this one's easier to move,
We're doing November.
easier to carry.
We go find out 27.
Move up.
I already got one wife, but then the little wife is trying to ask me to get out of my business.
Is it showing?
Don't do that to me. Curse me.
Just broadcasting.
Last two handouts, going once.
Does everybody have a handout?
You need one? Last handout.
One more handout left. You can follow along. And if you don't have one today, after you leave, make sure you take her business card, and there she has a lot of downloads, documents that explain everything that she was going to talk about today. And I'm ready whenever you are.
Okay.
Just take your time.
Can it take me standing? I feel so short here. And I'm short to begin with, you know? Is that okay if I stand?
Yes, stand, sit down. It's up to you.
Okay. Well, hello. Hi, my name is Deborah Gonzalez, and I am an IP attorney that focuses on art, music, and entertainment. Oh, I gotta scream a little louder. Okay. I'm really used to a very intimate setting with my artists. Usually we have about 8 people that come together every other month. So this is going to be new for all of us to get all this great information out for you. As you notice, I move my hands a lot. I'm from New York City, so it's really hard for me to just sit here in the chair to do this. So if you see me walking around, and it is streaming live to those artists who could not be here, I am going to try to face them, okay? Today's topic is about artists, social media, and the law. There are some legal issues that artists need to be aware of when they are doing social media. And we will look at some other legal issues besides what's happening in social media as well. The next session is actually focused on copyrights and art. So you're always welcome back to Binders every other month. I'm on the schedule here so that you can come and if you have questions to answer. Now, being an attorney, I'm going to begin with a disclaimer. Glad you got the joke, right? But the idea is that everything that I talk about today and the handout that you have is for educational purposes only, should not be construed as legal advice. All of you have very specific issues and questions, and we're going to be very general here. Now, at the end of the session, there is going to be some Q&A time, okay? But it's still going to be answered very general. There are lots of resources on my website, so make sure you get one of my cards because you can go there and pick up downloads and things Okay, so how many of you have a Facebook account? How many of you use it only for personal reasons, only family or close friends? Okay, so the rest of you, do you have clients or colleagues in the art industry as Facebook friends? Okay, how many of you have a Facebook fan page? Okay, how many of you don't know the difference between the Facebook personal page and the Facebook fan page? Okay, okay. Well, you know, when Facebook first started, right, and it started off, it was a very closed system only for Harvard students. When it did, when it did open up a little bit, then it was for anybody who had an email that ended in edu, meaning that you were related to higher education, right? Now it's open to everybody. But in the beginning, had an email that.
Right.
I sound terrible recording, don't I? Girls playing. But in the beginning, people who were in business, the only thing they could use was a Facebook personal account. So that's what they did use, not only for personal reasons, but also to showcase their art or to connect with colleagues or other artists around the world, not just the U.S. And in fact, 3/4 of Facebook accounts are actually outside of the United States. Okay, and they are available in over 60 languages. So just think about the reach that Facebook has. It has over right now 850 million active accounts, but that also includes this new thing called the Facebook fan page. And what that is an account separate from your personal account that's only focused for like business or even for a fictional character. So some of you may know I am a Walking Dead fan. Love it. Been to the goat farm. I know we have someone here whose business is there, where they recorded their episode Lobatos. And because of my love for them, I actually have a fictional character online, and she is called Zombie Esquire. She's lawyer to zombies. So if you want to know all the law related to zombies and everything that's happening on The Walking Dead, look me up on Facebook under Zombie Esquire, okay? So that's the idea of the Facebook fan page. Now, how many of you have a Twitter account? Okay, how many of you tweet? What do you tweet about? Everything. Okay. Twitter is really interesting. When it first began, you know, people didn't like Twitter. People thought that now it's very different today when you look at Twitter. Because what we're finding is that Twitter is a wonderful way to disseminate little pieces of information. Okay? How many of you use Google? Okay. There was an article that came out, right? And it said, "Is Google making us stupid?" And it was asking, like, do you remember anybody's phone number anymore?
No.
Okay, some people do. That's awesome. Great for you. But for most of us, you're probably like me. I lose my cell phone. I can't even call my mom anymore because it's in here, right? And that's what the article was talking about, that we've become so dependent on these kinds of technologies that we're losing some of the skills. Now, others would say, yeah, but they're giving us different skills, right? Maybe we don't need to keep that number in our head. Maybe what we do need to keep in our head is maybe some of the methods or techniques that we need for our art, okay? So that's Facebook, that's Twitter. You know what the number 3 social media platform is?
LinkedIn.
Pinterest. Yes, it used to be LinkedIn. Anybody here have a LinkedIn account? Okay. LinkedIn is important, From the business aspects, it's your professional resume. And what we know is that today people, when they meet you, right, one of the things that they will do is they will go and look you up on social media. I remember giving a talk, now this was in the beginning, and somebody came to me and they said, I Googled you. You were better than what I read about. I said, oh, thank God. You know, and then I ran to the computer and Googled myself. Now I have a Google alert on my name. Okay, and it's really cool. I am a professional basketball player in Mexico. Can't you see it? Right? It's cool. Okay, it's wonderful when I get those emails. Anytime my name shows up, right, anywhere in the internet, I get an email from Google that says, hey, Deborah Gonzalez XXX. Everybody should set up a Google alert on your name. It's very easy to do. Google alert, and it'll take you step by step. But it is really important because the thing about social media, 3 things you need to remember about it. Number 1, it's public. I don't care how many privacy settings you put on your different accounts, somebody's a friend of a friend of a friend who'll get to the info. And if you don't want people to know about it, don't put it out there. Okay? It's like putting it on a billboard. It's public. Number 2, it's permanent. It doesn't go away. Okay? There's a funny movie called American Pie Reunion. You guys know that movie?
Yep.
Okay? Well, there's a scene, right, in the first American Pie, he was recorded dancing like naked in his underwear, okay? And in the reunion movie, he's saying, man, I thought I had erased all of those, and there's this girl who he doesn't know bringing it up on YouTube, okay? It doesn't go away. Permanent. Even if you delete something, right? Even if you delete it, it could have been tagged by one of your friends. And so it's still out there somewhere. And number 3, social media is powerful. And it has powerful consequences. It has cost people their jobs, their reputations, commissions, clients. Okay? It is amazing how powerful they can be. So you have to be very, very careful. So, let's begin. Now, I am very informal. If you have a question, as I'm talking, just raise your hand and we'll try to get it in. We've got a big, big group, okay? So usually I go around the room and I ask people, what's your genre of art, right? What do you create? We're going to do it a little bit different today. How many painters do we have? Okay, sculptors? Mixed media? Performance art? Animation? Any filmmakers? Collage? Jewelry? Okay. Other that I did not mention. I was trying to make it quicker. It didn't work. I can't. Okay. Okay, so let's begin this. Why are artists online? Why are you online? Sell. Right? How do you sell?
You have to offer your art.
You have to offer your art, put your name out there, offer
Samples.
offers, examples.
Portfolio.
Yes. Your portfolio.
Create relationships.
Create relationships. Okay, these are all the reasons why artists are out there. Okay, now artists, why do you create your art? Passion, can't help it. They're, keep
Yeah.
killing people?
Keep from killing people.
Keep from killing people. There we go. You know I'm an attorney.
Expression.
Expression. Sometimes we have artists who do their art to document history. Right? We have a lot of artists who deal within the social context of what's going on, and they use their art to make a statement, not just an expression. But always, I think 99.99%, artists create art because you have no choice. It's in you. You have to get it out, right? And that's important to acknowledge and accept, because the other part of the art world today is the business part, right? How many of you have sold any of your art? How many of you want to sell more of your art? What's the biggest obstacle to selling your art? Knowing how. Finding the right buyer. Getting in front of people.
Knowing your audience.
Knowing your audience. Yes. Art is one of those things that is so personal. Not just for the artist, but for the buyer. What makes somebody buy a certain piece of art?
Something about it connects with them.
Yeah, there's something that connects with them. I can remember I was curating an art exhibit in New York, and this artist, very unique artist, and he used beautiful, lavish, romantic scenes and cockroaches. Now, you know, one of the good things about the law is that the law is not an art critic. The law is not going to decide whether your art is good or bad, whether it's marketable or not, whether it can be sold or not. The market decides that. The people decide that. How is it art? That's your decision, right? So anyway, there was a woman who went in there, and she saw that painting, and she was, oh my God, in love with that painting. You know, the romantic scene in the bed and all the roaches, it just did her in. It's like, okay, you know, what is it? And she couldn't explain it to me, what the connection was, what she saw in that painting. But you know what? That artist made a wonderful sale. It connected with her, and there was no way that she was going to leave that exhibit without that painting. Okay, she felt that much about it. So you just never tell us who that artist is. Okay, so, but in order to get that reaction, in order to get that connection, the buyer has to see the art. Okay? And we have different kinds of buyers. We have buyers who are collectors, right? They follow an artist, they see an artist, they think that artist is awesome, they're going to buy anything that that artist creates. And then there are buyers that are art lovers, that are really looking for certain pieces that maybe they want to use for decor, okay? And then there are buyers who are investors. Those buyers who go in and their purpose is to buy a piece that they feel is going to increase in value. Okay? And it's important to know these different kinds of buyers. We have seats up here if you need a seat. Okay, so when you're online, you've got to think about those different buyers and why they buy art. Okay. Whether it's to be a collector, a follower of you, and that's where social media really works well. Because if you're trying to develop buyers who are collectors, what social media does is it allows you to tell the story of your art. Okay, and I don't know about you, but I love knowing the story behind a painting, okay, or behind a sculpture, or behind a piece of jewelry. To me, that gives it value. So if I can speak with that artist and know what they were thinking, that means so much more than just looking at the piece. And you can do that with social media. You can have conversations about your art. Don't just think of using social media to put the dates of your next exhibit. Start documenting your process. I promise you, will help art historians, you know, after you're dead and you're very famous and your paintings are worth millions. Art historians are going to go back to your Twitter feed and say, this is exactly what they were thinking when they painted this. And don't laugh, because just so that you know, Twitter has donated all the tweets to the Library of Congress. You don't own your tweets. They are forever preserved in the Library of Congress in D.C., In 100 years, archaeologists are not going to be going through the sand. They're going to be going through the tweets to find out what we were thinking. Okay? I told you, it will never go away. You want to make sure of that. Okay? Now, there are different kinds of art that we put online, right? Sometimes when you're looking at presenting your art, it may be very traditional art, and the way you present it is through a photograph, right? They can't touch it, they can't see it online, but they may put it up in a photograph. You may put it up in a photograph. But we're going to see later on that there's actually art being created using social media, not just using social media to sell the art. Okay? On page 2, I just want to talk a little bit to show you also the power, some examples of the power of social media for art. Here's this artist, his name is Unger. He created these glass fire bowls, okay? And he found out that another artist not only was copying him, but was selling them and had actually gotten a copyright registration on his creation. Okay? Now, let's do a little side note. How many of you know about copyrights? Awesome. This is great. How many of you have art that's copyright registered? Very cool. Awesome. Well, copyrights are the laws in the U.S. that protect your value in the art that you create. Okay? And it's actually a bundle of rights. It's not just one right. There's 5 rights. Okay? First of all, it's the right that nobody copies you. Okay? That's the easiest one to remember, right? Copyright, nobody copies you. But you also have a right to derivative works, which means, let's say you did a painting, now you want to make prints. Now you want to make note cards. Now you want to put it on a mug. Now you want to put it on a t-shirt. You can do that because all of those are what we call derivative works from the original that you have. There are performance and display rights, and this is what allows you as the artist to put it up and hang it in a gallery, okay? To put it up on your website. Those display and performance rights bring those in there. Okay? So as you can see, there are different rights that you have. So Unger says, you know, this guy has copied me. I have all the proof that I need to say that it was originally mine. His problem was he didn't have money to pay an attorney. So what did he do? He went to Kickstarter. How many of you know of Kickstarter? Okay, Kickstarter is a website. It's based on crowdfunding, right? The idea that you can put up a project, and I've seen many sculptures of really large sculptures with the metal. Many of them use this kind of technique to raise money to get their materials, and they'll say, look, if you pay $10, $25 into this fund, I'm trying to raise $1,000, okay? So he put out a Kickstarter project to pay for his legal defense. He raised $10,000. He won his case. He got absolutely no money. He was over $20,000 in the hole. How can that be if he won the case, right? Copyright registration. Copyright is automatic in the U.S. The moment you create something, you have copyright protection in it. Automatically, okay? You're writing notes on those pages. Those notes are protected. Nobody else can take those notes from you. Okay? Not that you would sue somebody, right, for copying your notes. But the law also states that you must register within 3 months in order to preserve what are called statutory damages. Okay? Because what the rules say is that if somebody copies you, you are entitled to one of 2 things. The first thing is actual profits that the person made based on what they stole from you, right? Now, how many of you have heard of creative accounting? How many of you have heard of Coming to America, the movie with Eddie Murphy? Right? Great movie, right? You think it's a big success, okay? The person who actually wrote that movie sued Eddie Murphy, claiming that they had stolen it. And he won the case. He proved that Eddie Murphy had stole the story from him. You know how much money he got? Nothing, because they proved that that movie made absolutely no money. No profits. Everything was a cost. Everything was an expense. And that's what happens in the art world as well. That people will come and say, okay, I took your picture, I put it on a t-shirt, I sold 5 t-shirts at $20, 5 times 20, that's $100 of revenue, not profit. Well, I'm going to minus what I paid for my website, I'm going to minus what I paid for my marketing, I'm going to minus what I paid my art rep, I'm going to minus what I paid my attorney. Guess what? I don't have any money. You won the case, but there's going to be no money because I didn't register the copyright in time. If you register in time, the law says, you know what? You can get up to $750 to $30,000 each instance of violation. That means if somebody took your image, put it on their website for 30 days, I can go after them for 30,000 times 30 days. Isn't that a nice sum of money? In exchange for $35 of registering your copyright? Big difference, right? Big difference.
So what happens if it's registered after 3 months after you created it?
Well, if you register it after 3 months, you can go to court. You just got to prove actual profits. Right? That's the only thing you're going to recoup, is to recoup profits. Okay? Now, one thing that artists always ask me, how many of you are prolific? I mean, like, you create every day. Right? If I go to your homes, if I go to your studios, it is full of stuff. Yeah? Okay? And artists will say, well, yeah, I understand it's $35 each, but man, I've got thousands of stuff. You know, how do I register everything? And so, let me finish this and then I'll get to your question. How's that? And so what I always tell artists is that what is your signature work? What is the work that you put on postcards, that you put, that's the big image on your website, that if you go to a festival, that's the image that they put into the program. That's the image you register, because that's the one that has the most exposure online and will be the most vulnerable to be copied. Yes.
What's the difference between a copyright and a trademark?
Good question. How many of you have a brand name with your art? What's your brand name? Vintage Souffle. Okay? Trademark is about branding. It's about identification in the mind of the consumer, the buyer. Okay? Copyright is about protecting the value of the item you create. Right? So trademark identifies you in the marketplace. Coca-Cola. Okay? Nike, the swoosh. See the swoosh? You think Nike? You know that, right? What is the #1 trademark in the world? Anybody know?
Apple.
Starbucks.
McDonald's.
Coca-Cola.
DTM. ATL it is. No?
Mickey Mouse's ears.
Whoa, yeah, Disney.
That's the #1 trademark in the world. It is worth billions of dollars. Trademarks are really worth billions of dollars. And what happens with artists, you know, and this one is not really focused on the IP today, but I do want to talk about it because trademark is very important. When you're an artist today, the market is saturated. You have to distinguish yourself. And one of the ways to do that is by having a trademark, a symbol that goes beyond you, that encompasses everything that you do. And this goes hand in hand with having a business that's registered. Anybody here have an LLC, an S corp? Great. Again, if you can come to the next session that really talks about these issues, this is important, having those kinds of formations in business, because that protects your personal assets. Okay, so if you have a car, if you have a home, if you have children, if you have any of your assets, you need to protect them. Okay, I have a question here that says, you know, what is the annual amount of sales that an artist has to make that would require him to pay taxes on that income? $1. You make $1, you owe the IRS tax on that. Okay? So that's that first question answered in that issue. So those business aspects are very, very important. Okay. We also see online that a lot of advocacy is happening online for artist rights. Okay, so there are differences. Anybody here not a U.S. citizen or was born in another country? Okay, great. You know, the laws, our laws in the U.S. that protect artists are different from the laws outside. And in fact, we have the most lenient laws. I mean, we really don't protect our artists as well as other countries. And an example of that would be the European Union has a law that deals with moral rights, right? It focuses on the fact that artists have the right to attribution, which means having their name on something or not having their name on something, as well as having the right of integrity in their art, meaning that the way I created that art is the way it should always stay. Even if you buy it, you are not allowed to change it. U.S. is very different. We have what's called the first sale doctrine, which means that we can buy something, it's ours, it's private property, it doesn't matter if the artist made it. If I want to cut it up in little bits, I can cut it up in little bits. You have no right at all. Okay? So depending on countries, it's going to be different. And any of you, if you exhibit internationally, that's something to keep in mind. We had a hand up there.
Was there not protection at all?
VARA, the Visual Artists' Rights Act, was put into place to sort of help combat that. The problem that we have with VARA is right now it's only being used in public art, not in private art. So public art, like commissions that are done to make statues and memorials and stuff like that, we haven't even had a case go all the way through with VARA, unfortunately. All the cases seem to settle before we get a decision. So that law is still very vague. Yes?
Is using foreman right still a practice, or is that a joke now?
There is no such thing as a foreman's copyright or a foreman's trademark. Okay? Mailing yourself something does not work. It is not considered any evidence in a court of law to prove that this is your work. So don't waste the postage stamp.
As an artist, sometimes we're inspired by other art pieces. Now, if I see an image online, it doesn't have a watermark on it, doesn't have any kind of trademark on it, and I use a part of that image, and I'm manipulating that image, is that
That's copyright violation. Do you have access to it? Yes. Do you have permission to use it? No. One good rule of thumb for anything online is assume that somebody owns it. Remember, copyright is automatic. You do not have to put a copyright symbol on it. Just because they didn't put a notice on it doesn't mean it doesn't belong to somebody. And I'll tell you something, it's really easy to get permission. If you like something that somebody else has done and you want to use it in your own artwork, ask permission, right? Because there is something called attribution, where you take things, collage, mixed media, right? They take a lot of stuff, they put it together. But everything that they're putting together was original, right? They cut it up originally. If it was a collage of postcards, they bought the postcards, okay? So a great example of that would be SCAD in Savannah a couple years ago had their artists use these children's books from the 1940s, and the students cut out the kids in the pictures and then created brand new scenarios, okay? Well, that was considered fair use because they had bought the books, because they cut the image out, and then they put it on the new poster. They did not copy the image, right? They didn't draw the image or copy the image. They used the actual real paper from the book, okay? So, and that leads us to like blogs. Anybody here have an art blog? Great way to get some of your expertise out, great way to get your stories out. Some things to keep in mind, though, is you might see something, right, on another website that you want to talk about. Do not cut and paste. Link. use a link when you're doing that. Because even though fair use says, well, you can take certain excerpts to do a critique or to do a review, the courts believe that digital manipulation is very high quality. Right? If I copy something digitally, it is the same quality as the original. Okay? And so the court says, how can somebody distinguish between that? So don't cut and paste, copy now. Send an email and ask permission. Say, hey, I'm writing a blog, I saw your stuff, I think it's awesome. Would you mind? Can you send me the image? Can I use the image? You know, so many people do not ask permission that most artists, they're just thrilled you ask permission. And they're like, absolutely. And you know what? We'll do a reciprocal link. Right? You link to my website, I'll link to your website. Now you've reached a whole new audience just because you sent an email asking for permission instead of not sending that email and leaving yourself open to liability. Okay? Yes?
If somebody took picture of your work on exhibition and write review on a blog, is it considered for violation of copyright?
Photographs are really interesting. Okay? Because photographs have a number of rights, believe it or not. Whoever takes the photograph, they own the photo. Okay? But what they can do with that photo is restricted by law. Okay. So, you ever go to a museum? Can you take photos in the museum? Most of the time they say no, right? They want to sell their own postcards of it. They don't want you to take the pictures, they want you to buy the postcard. Okay? And many times in exhibits, you can put a rule, no photography allowed. But you have to make it conspicuous. You have to make it that people see that. Okay? You can also state if you are going to do a review, contact the artist. We cannot assume anymore that people will be courteous to us. Right? These little things here. Okay, how many of you have a smartphone? Okay, it's the easiest thing to do what? Snap a photo. Got a photo. Okay, but then what do I do with it? Well, people just think because they have the photo, they can do anything they want. Okay, so if you don't, yeah, that's me. So if you don't specify, right, what you're allowing them to do, then they're just going to assume and do whatever they want. It's up to you as the artist to set those rules. And that's the same thing on your website. Don't think, you know, that people are going to assume to know that they go to your website and they're not going to take, you know, right click on it and cut and paste or the screen captures and that sort of stuff. Put the rules out there. Okay? And this is important also for Facebook. Okay, some people here said they had a Facebook fan page. If somebody goes on your fan page and they put a negative comment, can you delete it? Guess what? If you didn't put the rules there, you cannot delete it. It's a violation of freedom of speech.
Where?
On Facebook.
Where are they?
You create rules. You create what are called community guidelines. Okay? You post them. Yeah, you can create a tab on your Facebook fan page. Create the tab, call it guidelines or rules. But you have to reserve the right to remove an offending comment. And you need to define what offending means to you. Okay? You have to let them know that comments are moderated. And if not, what you have done, if you don't have any rules, what you have done is create a free speech zone on your website, on your Facebook, okay? Which means that freedom of speech, First Amendment, is going to trump any kind of offensive language that goes out there. Okay? And most people, they don't even think about that, right? Hey, it's my Facebook. I can do whatever I want with it. Not once you open it up to the public, right? Remember, it's public, so you have to adhere to those rules. Okay. Yes.
On sites such as Flickr, where you can specify what type of copyright you have, and you say, okay, for personal use,
somebody from taking it and
No,
using it.
absolutely not.
See, that's the problem with this,
Understood.
right? Is that if somebody wants to do it, they're going to do it. Okay, and then it's up to you as the artist. The law says you as the artist are responsible to go and check out what's happening, to make sure that nobody's copying you, and if they are, to then deal with it. There are no art police. Okay, there are no art police. It's up to you. Drag, right? Let's create some. And it's funny. I'm on LinkedIn. I'm in a group called Characters Engage, animators from all over the world. And we had an issue come up where one of the animators found out he was in England, and he found out that a Brazilian company was using his image as their logo. And he said, "What can we do about this?" You know, and he was able to reach out to other animators who were in Brazil, who found him the information for the company, and we actually went through the consulate to get them to stop. Okay, because we didn't have any true laws that we can rely on. There are no international copyrights. He obviously was not registered in Brazil. Okay, he's in England, I'm in Georgia. This is happening in Brazil. But we were able, using social media and using online technology, get to resolve that issue. Okay, don't underestimate the power of those groups of people from all over the world to engage in and help out with it. Okay, I have an example here of the High Museum. Every once in a while they do a tweet up. I don't know if any of you have heard of that. You get free admission into the museum, and then what they want you to do is tweet while you're looking at the exhibits, and they allow you to take photos of certain things and you win prizes and stuff like that. It's a really cool event, and I think, I'm not sure if one passed or if there's coming up one in the year, but they will give you specific guidelines saying what you cannot photograph because of contractual obligations. Okay? So, here we go.
They had an exhibit some time back where you actually downloaded an app, and every time you went to a station, you could actually photograph.
Yeah.
But these are old masters.
Yeah.
15th century.
But it's pretty cool, isn't it? I mean, I think there's an app for everything. You know?
There's an app for that.
There's an app for that. So we'll figure it out here. I want to talk also for a minute about publicity rights and online, because this also relates to photography. You know, you may take a photograph of somebody, but be careful. If you do not know them, if you do not have permission in the form of a waiver to use their image, you cannot post that image online, especially if they are identifiable. And if it's a celebrity, be careful. You can get into trouble very, very quickly, or they'll want a licensing fee. And you're going to ask me, well, what about all these entertainment newspapers? How do they get away with it? Well, there's actually an exception in the law that views those entertainment magazines as news sources and allows them then to use the celebrity photos as fair use. So none of us fall into that category unless you want to create a magazine and get some media protection there.
What if
Okay.
you had like an editorial blog or something like that? Could you post them as, would that be considered Facebook?
It depends on your standing in the community. Okay, and if they recognize you as a legitimate source for those kinds of news or not.
So basically, if enough people like go to your blog every day, you have like 1 million viewers,
Yeah, you just have to prove it. Yes.
Ma'am, I have a question. What if like there's a lot of bloggers, and what if they kind of take your image and they blog about it? Even though it's good PR for you, it's all good stuff, they're saying good stuff, but usually you would just, you know, what would you do? I mean, they're saying good stuff.
You can
just
send
let
them a
it
little
slide.
email and say, I really appreciate that you did this for me. I do protect my intellectual property. So if you don't mind next time, please ask for permission. Okay, but I think you're awesome. That's great. Would you like a reciprocal link? If you ask for permission, I can give you a reciprocal link.
Okay.
Those kind of things. Okay, so it's a win-win situation in that. A lot of this is about talking to each other. It's about saying, hey, I'm trying to do this. I know you want to do this. How can we talk to each other and actually make it work? You don't necessarily always need to bring in the lawyers.
I have to be nice.
You have to be nice. Okay. The other thing with social media platforms are their terms of use. Okay, you have to be careful. I told you that Twitter donates all their tweets. Okay, that includes all the photos that you upload to it. Okay, if you use TwitPics, whatever's there, all of that's going to the Library of Congress. Okay? Facebook. Does Facebook own the images that you put up on Facebook? MySpace.
Say no, but we know what the real deal is.
Okay, here's the legal, here's the clarification of the legalese. Okay? You own your content, but you are giving them a worldwide, unrestricted license to use your image and then sub-license it out to third-party affiliates that work with that.
So in other words, you don't really own it.
No, you own it, but they can use it. Okay, so I'll give you a funny example. It's not funny for my client, but it was really funny. It was good that he was my friend because I was cracking up when he was telling me about it, but he was very upset about it. He went on Facebook and he was looking, you know how they give all these ads, and one of the ads were like meet singles in your area, and he looked over there and it was his wife's picture. And he freaked out. And he was like, what is your picture doing up there? I said, well, let's just look into this. It was her Facebook profile picture. Because she had put it up, they were allowed to license it off. So be careful what you put up there. Okay. If you are on LinkedIn, oh, one more thing about Facebook that recently changed. They have given everybody a new Facebook email. Have you seen that?
Yeah.
So make sure that you go into your settings and change it back to the email that you originally had messages being sent to you. If not, you're not getting any messages. Okay, so that was a recent change. And you do have to be careful with Facebook because they change all the time. Okay? Can you run a contest on Facebook and put up your artwork and say, okay, if you like me, I will then do a random sweepstakes and give you the art? No, it is against their policies. Yes, any contest that is run off Facebook is actually run off a third-party software. It is not through Facebook itself. It is against their rules, as it is with Google+. So be careful what you do. Even saying, you know, the first 3 people to like my page will get a prize, that's going to run you into trouble. Okay, so you want to be careful with that.
Can do it because I do fashion, and you can do it, but you have to sign up to get permission to do it.
And you have to use a third party.
Oh, yeah, that's true. But you can.
You just can't use
You
it.
don't sign up.
But people, you know, I've seen people go on Twitter and say, okay, the first, 3 people who tweet me back will get a prize. That is technically illegal. That's against a violation of their rules.
So they don't bother to sign up for the third party.
Yeah, Facebook does have a mechanism for that, but you have to pay.
Right, you have to pay.
You have to pay for that. And I would kind of doubt that there's anyone in this room who can afford their fees.
Really? Okay. So we talked about publicity rights that can deal with everybody. I want to talk about defamation online. What's defamation?
Disrespect someone.
Well, it's a little bit more than just disrespecting them.
You lie about somebody. You lie about somebody.
Yes.
Make up
There
stuff.
has to be a lie. There has to be a false statement. Okay? There has to be a false statement that's said about somebody, and it has to cause harm. Okay? Now, how might this play out? I'll give you an example that I had recently. 2 artists. One artist believed, jewelry makers, one artist believed that this other artist was copying her. Instead of talking to the artist, she then proceeded to go on the Facebook groups and special festivals website and just put all this name, including the other artist's name, where she lived, all these things that she accused the other artist of doing. Okay, and the other artist started having a really hard time getting into festivals because there was all this negativity surrounding her because of what was going on online. Okay? Don't say something if you're not willing to back it up and go to court. Okay? Because all it took was a cease and desist letter to stop that other artist in her tracks. And she was now threatened with a lawsuit. because she said these things online. There is real consequences to stuff that go up there, so be careful. Don't talk about people by their name, okay? Unless you're seeing something wonderful and you're admiring them and you think they are the best thing since sliced bread, but don't complain about people online. It is really bad form, and it will come back to haunt you. The art community is small, and in some places it's very incestuous. Everybody knows everybody else, okay? And you guys become judges at certain shows, and then the next time they're judges at certain shows. Just a little decorum. It's very easy online to just write anything, right? Because you think you're protected, you think it's anonymous. But you have to be very, very careful because there is no anonymity. We can find you. It takes an IP address. I don't need your name, but I can find you if you say something about a client of mine. So you need to be very, very careful about what you put out there, right? Because social media, what you want with social media is what? To create good vibes, right? You want people to respect you, to look well at you. When you meet a person who's always negative and complaining, what do? You avoid them. You stay away. Well, that's the same thing that happens there, okay? So you want to be careful with that.
I have an online question.
Yes.
So when you mentioned that the photo image, taking in digital images and creating your own, somebody says that they blend several images to create a new piece, and he wants to know how those laws apply to digital artists.
Digital artists is very interesting, right? Because they're starting with something that's digital already. What you have to be careful is that no one item in that digital montage is identifiable to a particular artist. It has to be what's considered transformative, okay? And if it's not transformative enough, then it will not be considered fair use and it will be held in copyright violation. So I'll give you an example. Jeff Koons. People know him as an artist. He does the big puppies, right? I'm from New York, so I see those big puppies everywhere, pink and blue and stuff. But, you know, he was sued because he created a sculpture of a photograph. He saw a photograph and he created a sculpture of it, and it was this couple full of all these little puppies, okay? And the court says it was a violation, and he says, how is it a violation? I did it in sculpture. This was a photograph, and they said, but it's a derivative work. It's exactly the photograph, only in 3D form, derivative work. It was not considered transformative enough to be held fair use. So you have to be careful about that, okay? We have an example here, again, about how powerful social media can be to resolve certain issues on page 5. This is the case of Stevie versus Urban Outfitters. It's a jewelry case. I don't know if any of you heard about this case, but it was an independent artist, jewelry maker, and she did necklaces that were in the shape of states, but she would put hearts in them. You have sort of a picture in there. Well, Urban Outfitters came out with the same exact necklace, okay? And so she didn't have it registered, so she couldn't go to court. So instead she went online, and bloggers picked it up, and it became national news. I mean, it was on all the morning shows and everything else. Urban Outfitters came out and said, well, you know, there's no copyright in this because it's the shape of a state, and the shape of a state is what's considered a fact, and facts are not copyrightable. Okay, just like ideas are not copyrightable. Only something in a fixed format is copyrightable, okay? So that's why we have movies and they're all the same, right? Boy meets girl, boy loses girl, boy gets girl back, or girl meets boy, and the same, but it's all the same plot, right? Okay, so that's what happened here. But because they copied the heart, the placement of the heart in each of those states, it was considered that it was copyright violation. And they settled with her, okay? But she used social media to get the word out. Okay, she used social media to get the word out. One thing that I will mention, I know it's not something that you guys probably want to think about, it's your digital legacy. What happens when you are no longer here to all that art that's out there on the internet, on your different social media accounts, okay? Now, Facebook has a process where your family or a good friend can memorialize your page. Okay, it's very simple. There's an online form. They can go there. They have to produce a death certificate, but they can then make it into a memorial page so that somebody doesn't come in and start posting as you, impersonating you or impersonating that artist. But you do have to let people know that that's what you want done. With your website, with your blog, with your Facebook, it really is important to have some kind of instructions. And in fact, it's so important that in April, the U.S. government actually put out a notice advising all of its citizens to put in social media instructions in their will. Okay. It is estimated that each of us will produce 88 gigabytes of data in our lifetime. What's going to happen with all of that when we're no longer here? Okay. But if you have value in your art, right? Think of all the Van Goghs. He was very poor when he was alive, but when he's dead, boy, he's got a lot of money. It's not going to him, it's going to somebody else, but there's a lot of money in there. Okay, and it's the same thing. What's going to happen to all of this when you leave? So it's important to keep that in mind. Okay. Let's talk about censorship online. Are you allowed to say anything you want online?
No.
Why not?
Well, you talked about defamation.
Okay, that's one reason why you cannot.
Homeland security.
Homeland security, yes.
Be viewed as potentially seditious.
Potentially seditious, so any kind of hate speech, for example, it's the same as you can't yell fire in a theater, kind of a thing, you know, you've got to be careful with that. But yeah, there are certain things that you cannot put online. Now, artists, you know, it's interesting because when it comes to art and censorship, right, artists will always rely on what? What's the argument for artists? Freedom of speech, First Amendment. Okay, and it includes the creativity, it includes, you know, my right to express myself and all of that. But those rights are not absolute. Okay, those who are right to freedom of speech is not an absolute right. There are reasons when it cannot happen. One of those reasons deal with the standard of obscenity. Okay, now what is obscenity?
Child pornography.
Although virtual child pornography has been considered First Amendment protected speech.
Really?
Really.
Wait a minute, hold on. So, if I have a child and my neighbor takes photos of my child naked while I'm at work.
No.
Okay.
Virtual child pornography, animated child pornography. Not real children, animated children.
Like anime?
Mhm.
Because a friend of my husband actually got prison time for downloading anime at work during lunch.
Well, that's another issue.
And he never, ever. They had no record of it, but it was his unlucky day. Because that day, the FBI were watching that feed.
Yeah, there's a difference between real child pornography and virtual child pornography, which is considered animated. And so the court views it that there is not a victim because there is not a real child. Therefore, it's protected as an art form.
Even if it's a likeness.
Even if it's a likeness. Okay, even if it's a likeness. But it's okay that you don't know the definition of obscenity because guess what? Neither does the law. We have a decision where the judge comes out and says, I can't define it, but I know it when I see it. That's dangerous because obscenity is a community standard. That means that what's obscene in New York is very different from what's obscene in Georgia, than what's obscene in Texas, than what's obscene in California. Okay? So it really is based on a community standard. So if you do anything that's edgy, you just want to keep that in mind. Not to censor yourself. Okay? Because then I'm doing this as a social critique. And I'll give you an example. The Brooklyn Museum had an exhibit. This was after 9/11, where they had the Virgin Mary. This artist had done a Virgin Mary, and she had used elephant dung. And Rudy Giuliani, who was the mayor at that point, was very upset and withheld grant money from the museum, claiming that this was obscene. Okay, and it got all sorts of notoriety and newsworthy, and it was held to be what? Fair use, right? Freedom of expression, because the artist was saying that that elephant dung was important to give the correct message about what they were doing. And you would think Giuliani would have learned his lesson, but no, 1 year later they had another exhibit, and it had a nude female Jesus Christ on the cross at the Last Supper. Okay, and again, he wanted to censor it, but community standards were that no, that was not obscene. He could not censor it, okay? But then, I don't know how many of you know of Robert, I'm gonna, yes, Mapplethorpe, okay, and all the nudes that he did. Now, the interesting thing about that is when he did it, the years that he did it, okay? Very different back then from what's happening now. Okay, and I do have to tell you though, the U.S. is one of the most prudish countries when it comes to the human form, nudity, and art. We are very prudish here. Okay, communities censor everything. So again, if you're an artist that's a little bit at the edge, you just want to be aware. Not that you stop yourself, but just be aware that those are some of the risks that you're going to take with that. Okay? Okay. So, on page 7, I just give you some examples of how some artists are actually integrating social media into their art or using social media to create art, because I thought they were pretty cool examples. The first one is an LA street artist, unfiltered take on Facebook as social cigarettes. And so he created this big cigarette box with cigarettes in it and then put Facebook around it and was talking about how addictive it has become, right? And what's the secret ingredient in the Facebook cigarettes versus that. And he used the Facebook logo, right? But isn't the Facebook logo trademark?
Yes.
So how could he use it? Why did they allow him to use it?
Artist expression.
Social commentary. Okay, not artistic expression, but social commentary. The idea that he was using it to make, right, a response to what was going on in society. I mean, he thought this would be the perfect metaphor for people to understand what was happening. Okay. The second one is by Kurt's Buzz, and what they do is they take all your Twitter feeds and then they create a portrait of you using your Twitter feed. Okay, so you have that there. And the third one, you know, anybody here do graphic design? Okay, social media and the internet has really opened up the world for opportunities in graphic design. So you just have an example here of these, you know, social icons. Here they look like cafe lattes right down there. But there are graphic artists who come up with their own icon sets all the time, and they're very creative and they're wonderful. Just another thing that we need to keep in mind. Somebody here said Pinterest was the third, right, social media platform. Anybody here use Pinterest?
Yeah.
Okay, technically you're all committing copyright violation.
Yay!
Yay! Okay.
Breaking the law.
Breaking the law. It's really funny because Pinterest actually hired the head lawyer from Google to help them with this issue. But the issue is that when you do Pinterest, right, and you go to a website, and it's the idea of an electronic bulletin board. And most of us have bulletin boards at home, right? You might use your refrigerator, you might use the back of your desk where you put things up that you see, that you quote, a picture, a magazine article that, you know, resounds to you. So this is the electronic version of it with Pinterest. But when they first came out, you could just do what? click the Pinterest icon, and then you're basically cutting and pasting an image. Well, what did I tell you about copyright violation? You need permission to do that, and nobody was getting permission to do that. But if you, on your website, put up social media tools, like an icon, so that people can share your blogs, if you put a Pinterest icon, you are giving people permission to pin your stuff. Okay? So keep that in mind. If you put in that social button for Pinterest on your website, on your Facebook, you are giving them permission to cut and copy and paste and use whatever on that website for their own use. I have another question here that relates to something that we were talking about. I'm curious how some people on Etsy can get away with selling a famous person's image on their goods. There are shirts with Elvis, Bill Murray, David Bowie, etc. on shirts. Is it because it's just their image, not their name with it? Well, there are two answers. Number one, either they are paying a license to use that image, or that particular person that they're using does not have a publicity right. Okay? And I'm going to give you an example of this, Marilyn Monroe. There are certain states in the U.S., a publicity right is by state. There's no federal law for publicity right. It's by state. And so some states will recognize it. Georgia was actually the first state to recognize a publicity right for commercial value for an individual. But there are some states that right terminates when the person dies, and New York is one of those states. So I always tell my celebrity clients, don't live in New York. Because if you die, you lose all your rights.
They did an episode like that with The Simpsons. Well, who went and kill all the celebrities and
Yes. And so Marilyn Monroe was deemed by a court to have lived in New York. So when she died, guess what? She doesn't have a publicity right anymore.
Is it where you live when you die, or is it if you live there?
What's listed as your domicile at the moment of death and your residency at the moment of death. And so these, Elvis makes more money now than ever. Michael Jackson's estate makes a lot of money. So if people have signed a license, they can use the image, right? They just have to pay for it, okay? Those who are not paying the license fee, they will be sued. And I have a colleague of mine, and that's all he does, is litigation over dead celebrities' rights. He has as his clients the Frank Sinatra estate, okay, Audrey Hepburn, okay? So sometimes either they have the right and it's licensed, or they don't have the right, and so it's free. People can take her. There's a case right now where there's a company trying to do a hologram of Marilyn Monroe. They did a hologram of Tupac at a concert, okay, and they're trying to do that, but Marilyn Monroe's estate says that they have a trademark claim, not a publicity claim, because remember, they have no rights of publicity because she lived in New York, but they're trying to fight it as a trademark claim, that her image being used in any other way would be confusing.
Who on earth has her estate? She didn't have any family, never had any children.
Her manager in her studio. Her manager in her studio, yes.
what happens, I saw, I watched like those, pawn shows or whatever. And there was, a guy that's, I heard is being sued right now by Michael Jackson's, estate because he was a photographer. He took the pictures, so they're all original. But they're suing him for selling them on TV.
Yeah, because he owns the photograph, but he doesn't own Michael Jackson's publicity right.
So you can, even though you're the owner of,
Don't even get me started on copyrights in music. We can do a whole hour on that one alone.
George Clinton.
great question. At what point is something considered public domain? Because the court does recognize, hey, we do not create in a vacuum, right? We need inspiration. We're going to get input from all over, sensory input from all over. One of the things that happens is that copyright will last only a certain amount of time, okay? Before it goes into what is called the public domain, where anybody can use it. Now, that usually lasts the life of the author and up to 75 to 95 years, depending on who the author is. Okay, you're going to say, well, what do you mean depending on who the author is? Well, the author could be the artist, but if you're commissioned to do something, you're no longer the author. The person who commissioned you has the right to do the copyright, not you. Okay? So that's why I say it all depends on who the author actually is. It's a safe bet right now. Anything that was created before 1923 is in the public domain. Unless it's foreign. If it's foreign, then that's a whole different calculation. Okay? If you see anything produced or created before 1923 is what we consider in the public domain.
But does that apply to something that you created or somebody wanted you to create another copy of that?
What do you mean?
Well, I make custom clothing. I put up a copy of that dress. You have to commission me to make that dress for you. It's custom. You don't get any money back.
Clothing is not copyrightable. That's why, the day after the Oscars, you have all the knockoffs of the dresses. Clothing is considered a utilitarian item. It has a functional aspect to it, and therefore it is not copyrightable. It's something that fashion designers have been lobbying about for years. You can copyright a belt, you can copyright a hat, you can copyright a purse, you cannot copyright an item of clothing. Unless it's a costume.
What about shoes?
Right? Shoes are interesting. We just had a major case about the red heels on shoes, where the artist Louboutin, he's famous. His shoes always have the red heel, and he claimed that it was trademarked. Guess what? The court tore it down. Said it's not trademarked. He has no protection. So everybody in the shoe industry is really upset right now with the law.
So clothes are not copyrightable?
Unless they are a costume considered only for artistic value.
But what about patterns? If you buy a pattern?
Pattern is not clothing.
Oh.
Right?
Okay.
A pattern is not a piece of clothing.
Can you repeat your point about the copyright lasting for the life of the author?
Life of the author for 75 to 95 years, depending on who the author is.
And then so like, can you leverage on that through the author thing? I didn't catch that.
So it's you personal, you created a painting, it'll last 75 years once you die. Right? All your life plus 75 years. And this was so that we would be equal to what's going on in the EU. In the US, it used to only be 50 years. And then, how many of you know Sonny Bono? Right, Sonny and Cher with the hair. Okay. He became a senator, and Disney backed a bill for him. It was called the Bono Bill, that would then extend copyright for 25 years. And the argument was, well, in Europe, the artists have that protection, so we should have it here in the U.S. And the court said, we're going to do it this one time, but we're not going to do it again. Okay, so they will not extend it. And the only reason why Disney pushed it was that their clip of Steamboat Willie was going to go into the public domain.
Yeah.
And that's their bread and butter. They did not want to lose that. So now, if you notice, if you anybody here have kids that watch Disney cartoons, if you see their DVD, in the very beginning, they show Steamboat Willie so that they can protect it every year. How smart. Yes.
So in relation to that, for instance, my husband and I own a business. He's technically the artist, but would that work be copywritten for his lifetime plus 75 years, or if we own the business together, is that some way treated as a commission?
It depends on how you are promoting the art. If you're promoting it's just being promoted and signed off as you guys as independent artists, it's only your life plus 75.
How about when you have children? If you pass on to the higher life and then you have kids, can they renew that copyright for you?
There's no copyright renewal. There's no copyright renewal anymore. That used to be prior to 1976. You would have to renew copyright, not anymore. We had a restructuring of the copyright laws, and so now it's just life plus the 75 years. There's no renewal. So your kids only have 75 years after you die to get any value out of it, and then it's over.
And it has to be copied to get any value, right?
Well, you want it to be registered, yeah, but there's still a lot of art that's not registered, right?
And does
See,
that apply to?
one of the issues with artists is that so much depends on your reputation, right? That's what gives value to your art. It's not just your craft, it's you. When you sell art, you're selling you. You're part of the entire package. Okay, so I usually tell my clients, you are the brand. Okay, and it's going to last, if you do it right, it will last 75 years after your death. Okay? When you do have children and you do have some success, you do have to put it in your will who's going to own the intellectual property of your artwork. And I'll tell you right now, you know, when it comes to wills and stuff that's left to kids, do it right, because it's going to create a lot of hell afterwards. You know,
Okay.
name people and say, give it to this one, give this to this one, give this to this one, but don't just say, you know, sell it all and split the money. Okay, I've got a matter right now of a tattoo artist, and he was killed tragically in a car accident, and they want to do like a documentary on his life. Well, he was married 3 times. He's got kids with all these women. We've got to go get life story rights from everybody. From his siblings, from his ex-wives, from their in-laws, if they're going to be part of the story.
That's amazing.
Yeah, it's a mess. It's a mess, but that's life, right? But his brother wants to memorialize the documentary. He can't do it right now without everybody signing off. And you know, some ex-wives, they're not happy.
What's the latest with Daniel Moore? Are you familiar with him, aren't you? Is the artist who paints the sports art? Is it Auburn or Alabama?
Yeah,
It's been,
this is really interesting because this happens all the time. We've got a great case that deals with sports, athletics, and, you know, painting and photography. Now, colleges and universities do heavily protect their intellectual property. CCL, which is Collegiate Commercial Licensing, as well as now, I think it's Exus for the digital rights. So everything is, you know, really protected. And the national sports bureaus also really look at protecting their intellectual property. So there's been a number of cases of using athletes' likeness, like in video games. We have a couple cases. Some of them say you can't use it without their permission on a fee. Others say you can because it's First Amendment, and if they got the license from the university, then there's all that issue, okay? But then there's the other issue of, can this photographer who takes these photos at the games, can he then sell them, okay? And a lot of that depends on if he was hired by the university or the college. If he was hired by the newspaper, then it's considered a work for hire. It was done within the scope of his employment. He does not own those. Okay, whoever pays him, whoever employs him, owns that, unless he had a contract that said that he retained the copyright to it. Okay, and so if you're ever given a commission, make sure you look at the language in that commission contract as to who keeps the copyright to it.
does that fall under intellectual property?
Intellectual property is the umbrella name, and it covers copyrights, trademark, trade dress, service mark, and patents.
That's the reason why a lot of the old actors from Saturday Night Live, the characters that they create, they can't take them with them when they leave. That's the reason why.
No, the writers created them, and they created it for the show. The actors did not
like Google owns the rights to what you're storing.
Again, you have to look at their terms of service, and it's not necessarily, you still own it, but they have a license to use it. Okay, so I always tell, my clients, best to have your own personal website to put your artwork. Best not to put everything, right? Put signature pieces, make sure those pieces that are out there are registered. Okay, you can have password protected sections on your website. So if you have a client that you're working with, that they want to see some extra stuff, you can set up a page just for them that's password protected. Okay, so there are lots of things that you can do.
Do you know about Digimon? Do you know about Digimon?
Tell me a little bit more.
Every time I finish what I'm doing, I go out to Digimon and I put a watermark. Is my work protected with a watermark? Even if that watermark has Digimon, which charges you so that you can even distinguish whether or not they have the right to copy it without your permission.
But Digimark is not the federal U.S. Copyright Office. Okay, and if you don't register with the federal U.S. Copyright Office, it's not registered. Okay, what the watermark does is it frustrates people who want to steal it. Right? 'Cause now they got the image with the watermark. That's all it does.
Okay.
But it doesn't give you any legal standing in the court of law.
Gotcha. No, I just wanted to know that even if you put a warning on there, it doesn't mean anything.
Yeah, I mean, people are told all the time that don't steal, right? Don't copy, but people still do it, unfortunately. And that's what makes your job so hard as an artist, because you're trying to create, but you've also got to put on that hat of, who's doing what out there with my stuff, and you've got to be aware of it.
And what about to go back? Still not clear for me. So, in case my work is sold, my painting is sold, I still keep my copyright, right?
Yes.
Yeah.
You keep your copyright in the image.
But you mentioned that owner could destroy it. With the right to destroy it. Why? I have copyright. They could then
Copyright
check.
is separate. Copyright in the image is separate from possession of the item. Okay, so you sell the item, you don't have any right to that item anymore. You have the right to the image that you created, but not to the item. Because they bought it. The first sale doctrine says, I buy it, I can do whatever I want with it. So if I want to, put it in a bonfire, I can do that.
That's a whole new reality.
Interesting.
I don't know, and I haven't sold it. I have stuff, and I don't. See, now you make me not want to sell it. But how do you make money? I mean, that makes you nervous, doesn't it?
Serious.
So look, I had a situation where I illustrated a character for an individual, and it didn't come back until everything was done. He wanted to change the eyes on the character, which would be changed without it. I didn't want him to do that without first coming to me first to allow me the opportunity to do that. Should I have put in a clause in my contract to make sure that nothing will be done without my permission first?
It's really difficult because that was a work for hire, and in animation, they have every right to change anything.
Well, it's an illustration.
Illustration. Yeah, I mean, if they're hiring you to do something as a work for hire, they can do anything they want with it.
Even though I couldn't do a clause or anything at all.
No.
So,
Because you're doing it for somebody else. It's not yours, right? It's not yours. You're creating it for somebody else. And this happens all the time in animation. And I know there were some people here who raised their hands in animation. But usually what happens is somebody will have an idea for an animation. The illustrator will come and they'll create the look and feel in that character. But it's a work for hire. They don't own the character. Okay? And so they can't, if the creator wants to go and change the color and change the whole thing, they can. Yes.
I do murals sometimes. When you get my mural, I get a lot of people who want Disney characters or from Yoda's Rule. stuff, what do you do in those cases? You just decline the job or
You have to decline it. It's illegal. It's copyright violation. Okay. You are allowed to do those paintings for your personal use, for your portfolio, but not to sell that. Okay, that is a no, 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 no. Even for free, you can't do it. It's a copyright violation.
So those daycare centers that you would see in neighborhoods with those characters out there,
You know,
they
in my
have no right to
neighborhood,
do
it is so funny. In my neighborhood, there's a restaurant called Olive Oil. And they have olive oil on it. And I cringe every time I go by there because I know that it's illegal. On that. We had a hand here and then we'll come to you. I'm sorry. Come in.
Black door.
Okay, let's listen.
Okay.
You know, when
So,
they're being asked.
yeah, did you hear that last one about the mural?
No.
Okay, he was asking, like, he does mural, and sometimes people want, like, for their kids' room, you know, put Donald Duck or Mickey Mouse.
Right.
He can't do that. It's illegal. It's copyright violation. That's why if you go to Home Depot, you actually have these stick-ons, right? SpongeBob. I mean, they license that. They make money off of those characters. One thing about Disney, same as Nickelodeon, same as Cartoon Network, they don't only copyright the animation, they trademark each character. Okay, so they have double protection in that. So you want to be very, very careful. Here and then we'll come back.
Is there a way to differentiate between work done for hire, maybe I'm using the wrong terms, like I work for somebody 9 to 5, and I do a piece as an artist, but customizing an existing design that I have copyrighted for a particular person in terms of size, shape, proportion, something like that.
But you're copying yourself.
I'm copying myself.
You gave yourself permission to copy yourself? Then you're fine. Right?
And
Because
it's not a
copyright-
work for hire because of the individualized nature and the fact it's based on my other designs.
Oh, wait. Did you make the original as part of your job?
No, the original was made as a work of art.
Okay, then you're fine. But if it was made, if the original was made in your scope of employment, you don't have a right to.
Right.
You can't manipulate it. Now, there was somebody over here.
Okay, if someone commissions you for a project and they don't use your word like a cartoon or something, are you allowed to reuse whatever you drew or something else?
Okay, here's a good question. What if you're hired by somebody to draw something like an animation and then they don't use it? Can you reuse it?
No. But they didn't think, or let's say they get it, they don't think it.
You gave it to them and they
No, you
didn't pay
didn't,
you for it?
like how like you do a presentation and they don't pay for it or they decide not to use it, how much of it do you still own?
Well,
If no transaction was actually made.
If no transaction was made, it all depends on the contract.
Okay.
I mean, that's the easiest answer. It depends on what was written in the contract. Okay, because sometimes they may not use that, but what they ultimately end up with is very similar. And so they might not want you using that for somebody else. Okay, it's very different from a scenario where you created a character and then you're trying to shop it around versus them coming to you to create a character for them. And then we'll go back.
A question about public objects in public. You photograph, say, in traffic, you might get a car tag or an airplane call number. Is that violated?
And then you use it in art, right?
Well, it's
And
my
then you
photography.
recognize
It's
it.
my photography.
And then you recognize it.
I might show the picture, I might post
Okay.
the picture.
The laws say that if you can take a photo of something while you're in a public space, that's fine. If you're in private space, that's a problem. So be careful about taking photos, for example, in a botanical garden, in a zoo. That's private property, right? You have to pay to get in there. Okay, hold on, let me just get over here. Sir, you had a question?
Yes, as a
But
tattoo
keep that
artist,
mind about Foursquare.
as tattoo artists, I know a lot of us get asked to do, I want this Salvador Dali piece on my back. No,
Tattoo artistry is
Are you replicating the piece of art?
you're supposed to transform it to a certain extent, right? And people are going to argue, well, it's on skin, it's transformative, and as the body grows older or the skin changes, it transforms it again. Okay, but yeah, it sags or whatever, you know, the beard gets longer, I don't know, the hips get wider. But Mickey Mouse, no, you're going to run into trouble because Mickey Mouse, you've got the trademark. You've got to be careful about anything that's distinct. But don't forget, Salvador Dali, some of his stuff is in the public domain already.
Yeah.
Right? But Mickey Mouse is not.
Where do I find out what's in public domain?
Each item is a separate research to find out whether it's in the public domain. And you know, anything that was created between 1923 and 1976, there's a whole formula of calculations to figure out whether it's still in the public domain or not. That's why you hire the attorney.
I was just wondering if you could go over the 5 rights of copyright, even like the 5 rights of the gift, don't we got
The 5 rights, the 5 bundles of the copyright. Okay, it's the bundle of copyrights, and so we have the right not to copy, the right to derivative work, the right of performance, the right of display, and the right of distribution.
How expensive is it to get copyright?
$35 if you do it yourself online.
But that's per
item.
derivative or?
Per item. Right, per item. Now you can put them as a collection, right? You can register a collection and then just have one fee.
I think a lot of, I'm old school, a lot of copyright laws have changed, I think. But it used to be on printing, you could sign your name, put it a small copyright, C in the circle and put the date, and that protected you or copy it. I mean, but copy the work, is that no longer true?
You don't need to put the C, copyright is automatic, but to go to court, to sue somebody, you need to have it registered.
So that no longer is legal because it was for a long time.
Even back then, you just couldn't take it to court. You have copyright protection, but if you want to take somebody to court, you have to have it registered. That has always been the rule. And then I'll go to
when you were talking about the coming to America, I know they had a similar situation like that, like the Matrix, where it's like a woman who claims that she wrote the Matrix and then the whatever the studio took the idea and made a movie. And so how do people get in those situations where people end up having their materials and being able to distribute or having access to their materials that they feel the ability or to use it?
Okay, so the question is that, you know, similar to the Coming to America case, there was a woman who said that she had written The Matrix and that it was copied from her and she did not get compensated. The copyright does not protect ideas. And the court goes through a very detailed comparison between the original and the supposed copy to see if there was copy, and if what was copied was copyrightable to begin with.
Can you use non-disclosure to protect?
Copyrightable means that it falls within the subject matter that the court will protect. Okay, so let me give you an example. Everybody here seen West Side Story?
Yeah.
Romeo and Juliet?
Yeah.
Nomeo and Juliet?
Yes.
Okay. So Romeo and Juliet, I mean, they're all basically the same plot, right? The difference is place, where it happens to be, in who the actual characters are. Okay? So that would determine whether it's copyrightable or not. Let me just move on to her and then we'll come back.
My question is, commission, but commission was not the real art form, but just image. To put in the brochures and stuff. Dr. Fry, could I sell my original work? I mean, I sold image, but I have original.
It all depends on your contract, right? If you're doing commercial corporate work, like these photos for a brochure, you have to be careful because they might be paying for the copyright as well. Okay, because no corporation wants you to use their images for somebody else.
But to sell it as an art form.
It depends on the contract that you have with them. Okay, because they might want it to be exclusive, right?
I have a question about copyright. Has something that submitted there for copyright, and copyright is sent in as a mark, and still it hasn't gone through. So is it copyrighted the moment you submit it, or is it
No.
copyrighted the moment they approve it?
It's copyrighted when they approve it.
Okay,
Right,
so
I mean, you
there's
have
3 months
copyright automatically, but that registration is once you get the certificate of registration back. Now, I don't know if you've gone to the ECO site and checked the status.
I called them, and friends also told me to expect a good 6 months before anything, before you even hear from them or anything like that.
For copyright?
Yeah, it's for a song.
Okay.
How do you say the right word, copyright for the song, right?
Yeah, now, in music, you have the copyright for the lyrics and composition, you have the copyright for the sound recording. Which copyright did you get?
I've got the music and the words on the one sheet, and that's what I'm talking about.
It shouldn't take that long. Usually if you do it online, within 6 weeks. It used to take 2 weeks, but they're really backlogged. See, if it was trademark, I would tell you, it takes 4 months on a trademark just to get an attorney assigned by the trademark office. But copyright, I'm really surprised that it's taken that long. Make sure there's no problem with the deposit that you did.
Well, I had sent it through mail because I was having trouble online.
That's why it's
Then I
delayed.
sent an extra $30.
Yeah.
It costs $60 in mail and $35 on.
Right. And that's where the delay is. Anytime you mail anything in, it always takes longer.
We're talking about this 3 months, as long as it's done within 3 months. If it takes them 6 months, 9 months to get their act together and get approved, what happens to the artist's work? It's not
Well, they will put the date of when they receive the application. They won't put the date of when they give you the certificate. They'll put the date of when you receive the application. Now, there was a handout, and then we'll come in.
I had a question. What about things that are published as clip art? Are they, you can use them anyway, or is that?
Depends on terms of service. So like Microsoft Word, if you're using any of the clip art, they're royalty free.
And then about the taking photos on private property, are you allowed to make work from those photos when they're okay? Or are they still?
Depends what kind of
painting,
work.
Like
And
a painting based on a photo that you took, like in a botanic garden or a building or.
It depends on the work and it depends on how identifiable it is.
If you submit a collection for registration and they find a segment too similar to previous copyrighted work, will they reject the entire collection? Or do you have to,
What constitutes a collection?
So a collection is more than one piece that you're registering together. Okay? So let's say a collection of paintings and the theme is summer. So I have 10 summer paintings. It's my summer collection. Okay? Now to register, and I'm registering them all together, I have to then refer to them always as part of my summer collection. If the Copyright Office, unlike trademark, to get a trademark is very in-depth. Basically, getting a trademark is going to court, which is why I always suggest an attorney. Because they have attorneys at the trademark office who are trying to deny you the trademark. Okay, and so they do, there's a lot of prior art searches, there's a lot more in-depth and all of that. In copyright, they don't do as much search. Okay, so reasons to reject reject copyright would be if it's utilitarian function. So I don't know if anybody here ever does like forks, knives, plates, mugs. Okay, any of that stuff is not copyrightable. I don't care how much sculpture you put into that mug, it's not copyrightable.
So same as furniture?
Furniture is the same thing. Okay, now you can get what's called design patents for some of these things, but that's going to cost you about $10,000 to $20,000.
It's a racket.
Expensive mug, yeah. Was there another hand up over here? Yes.
I have two questions. The first question is, I wanted to ask you about nudity on Twitter and whatnot, because I make flowers out of porn magazines, and so I've been really kind of, nervous about that. I make sure that, I make sure everybody's 18 that follows me. I tweet that, like, you have to be 18 to follow me, and I have the little, private, it's not protected tweets, but it's, I have, like,
You have to approve them to follow you, right?
Well, no, I have it open. It's
Okay.
not.
No. If you're saying that they have to be 18 to follow you, you have to make them private tweets.
I have
And
to.
you have to approve that they follow you.
Okay, so like
Because there is no way that you can guarantee that they're over 18 if it's open.
right, and so I wanted to ask you about that because I was also, just what I do, I have to kind of be aware. So I was following the porn star Tia Ling, and she had all kinds of crazy stuff on there on her timeline. So I, but under how it's open right now on my settings, it's open, but it's like I check, this is sensitive content on Twitter specifically. And
But I would suggest for you, since you've already made that statement that they have to be over 18, privatize the tweets.
But I'm worried it's gonna, like, I'm gonna have a hard time gaining followers.
Then don't put anything that would be considered
That would be even.
okay, and that would be any depiction of intercourse or male frontal nudity.
Okay, but like, what about like nipples and stuff?
Nipples
Oh, that's
are
fine.
fair game.
Okay.
Boobies are good.
Okay, so no.
Did you pitch him?
No intercourse and no frontal nudity. Okay, great.
Male
No
frontal
male
nudity.
frontal nudity. Okay.
Yeah, there's a double standard.
But like females are okay, like vaginas and stuff are all right.
Not an open vagina, right? Closed vagina with the hair, you're not seeing anything, it's pretty much covered.
Start talking about porn and y'all go crazy.
Here's my second question, because I feel like it's important for artists to cross promote with other creatives and stuff. So one of my strategies is I would like to, get with musicians and put out their songs and help promote their songs and kind of put my artwork to it. And I don't mind licensing my art out for their albums or whatever, but like I definitely want some kind of contractual agreement that says, listen, this is for promotion only. I'm not
Well,
making.
you also, you need a contract, right, for them to license the image.
Right.
You're gonna need some sync rights to sync up the audio with the visual. And that all depends on how they're using it and how they're doing their recording. So there might be even a master license use.
Yeah, so I don't know, like, what we need to do.
That's beyond the scope of this
Yes.
session.
I have one quick question.
Yes, and then we'll go over there.
All right, so you do web design, you do content, design content for websites and online stuff, and the client sends you some Google images or images they pull from somewhere, and you kind of don't know where they come from, or you kind of recognize some things, and you use it, and are you liable for the infringement, or are you liable for the work that you did, or
You're
who is liable?
for it. You are liable.
The artist, the designer.
And so you create that website, okay, it is your responsibility not to use something that's copyrighted. And you need to educate your client. So any image, and this is a good practice, if any of you do web design or graphic design, any image that a client gives you, make sure you have the old-fashioned word provenance for it, right? Where is it coming from? Do you have permission? Even if they use their own photographer, okay, make sure they have a release to put those images online. Okay? Yes.
Okay, in a lot of the jewelry magazines, they will give step-by-step instructions on how someone has created a certain piece. Now, I would assume you cannot duplicate it with your same design, but is the technique
is 7:47. We have 13 minutes before the shop closes. I think we have time for like 2 more questions.
The Foursquare.
Foursquare, yes, Foursquare. Okay, awesome. Right, Foursquare. You check in. How many of you use Foursquare? Okay. One thing that I will tell you is that if you are using Foursquare to get your points to become mayor, check in after you leave. Don't check in when you get there. Because this way nobody knows where you're at. You're safer and you still get your points. So like when you're walking out the door of the restaurant, check in. You know, because you're leaving. But it protects you so nobody knows where you're at and you still get your points for that. But when they ask of you taking photos and you take photos of certain places, right, like a park that you're in or something, you know, one of the things about Foursquare is on their terms of service, they're also going to say that they have a license to use the photos that you put out there. So you do have to be careful because ultimately it is you who will be liable, not Foursquare. Foursquare is considered like every other ISP, internet service provider. They have what's called a safe harbor in the copyright laws. They are just a channel. So if you put up copyrighted materials, you will be held in violation, not them. Now we just had a big case turn on its head, which was Viacom versus YouTube or Google. And first it went for Google stating the safe harbor. Now it seems that since Google and YouTube was on alert that there was copyrighted materials, and they did not take it off in time, that they may be liable. So if you know that somebody has your image on a website, you can contact the website provider to take it down. It's called a DMCA takedown notice. DMCA takedown notice, Digital Millennium Copyright Act. DMCA.
So when you're in the restaurant, and you're trying to become mayor.
Don't take photos.
Don't, and you know, that's a private space, isn't it?
Yeah.
Okay. So
Don't
you
take
can't
photos.
get an image. I try never to shoot ahead of anybody.
Yeah.
Or
And
if I have
if you want to shoot, you're there at a birthday celebration and everybody, and you say, smile, this is for Foursquare, and they say, yay, you're okay. It's like, you know, I'd say, last Christmas, last December, companies started confiscating smartphones before people went into their corporate parties. Why? Because they didn't want people taking photos and putting it on Facebook. Okay, and by the way, if you ever go to a children's party and you take pictures, don't put it on Facebook. You don't have permission to put any of those children up there.
If you get something signed, can you do that?
Yes. You have a waiver, if you have a permission, absolutely. But if you do not, don't. And I just,
By word, correct? You have to have it signed.
you can record
Is
it.
it okay?
I had a photographer. This was really neat. Before he took any photo, right, he would record them, giving him the approval.
Does that work?
It works. It works. It's dated. It's dated on the recording.
So, email, can I use your likeness on my website? Is that fine?
Yeah, but make sure you get a response from them. If you send that out, you don't get a response, don't use it.
One last question over here.
With the new social media thing that's out now, what's the legalese about Instagram? Since that's the new thing now. You got any
Let me
suggestions?
put it this way. The law is reactive. It is not proactive. Social media and all of these technologies, really quick. It's evolving quick. The law can't keep up. Okay? It's just like Pinterest. We don't have a copyright case against Pinterest. We're waiting for it. We really are. We're waiting for somebody to sue, and we know it's coming, but it just isn't here yet. Okay? Same thing happens with Instagram. Now, we had an interesting scenario, though, with a picture that was up on Twitter. If you remember the rocket that exploded, and we had an image that a woman took with her cell phone. Okay? And all sorts of copyright issues came out of that because the media just took it.
The thing kills me about Instagram, you got people that be on there, put pictures of weed on there. And it's like, man.
Last question. Last question.
Digital timestamps. Can they validate your work?
Digital timestamp.
Timestamps. My camera has a timestamp. It times my pictures. Some of them also tell you where you were if you have a GPS on your camera. Can that count for validating?
It can count as a start. The problem is that the court will not accept any photographic evidence because it's too easy to manipulate.
Yes, just what you say, you can manipulate that, no
You know,
problem.
so you can start with that, but it's not going to be the only thing you're going to get.
Right.
Okay, you really need that.
Because
Do
somebody could
sign
have-
your work. Do date your work with the year. Document your work. Keep your own inventory. That's important. I'm sorry we don't have more time. Come back, see me again at Binders. Go online on my website. Thank you.
Give her a hand. Deborah Gonzalez, this fire. What is this fire? What is that?
Esquire means that I'm a practicing attorney.
All right. Cool.
I passed the bar.
Take her card. Her card is up here in the front table. If you have not signed our form, you can this right here. Please sign it. The next Blackwood conversation is at Hippopotamus in downtown by Georgia Tech, inside the Billmore Hotel at the first floor. That is August 20th. All right, so plan ahead. 4 weeks from now, and we'll have Flavor Dave talking about online marketing and branding and what it takes to do. And in 2 months from now, we'll have to be back and listen to this awesome attorney here today talking the good stuff, all the stuff that's important for artists. All right, see you next time. Thank you. Thank you, bud.
I am here every other month.
See you soon. If not, if I don't see you before, I'll see you at Emory. Take care. Goodbye, my man. Thank you for this evening. Enjoyable. Thank you.
Special thanks to iNetwork for the snacks. Special thanks, Jason Thomas over there, and Sway. I'll take it home. I got kids. Okay, babe.
My daughter just texted me. Or she just called me. She couldn't get through. She left a message.
All right, brother. Thank you very much. Yes, yes.
She's 18. She works at she has a job working at she's working with a seamstress, and then she has a job. I guess she's supposed to be trying to get a job working Family Dollar. So I'm trying to figure that one out. Yeah, that's what I'm saying. It's like, man, you know, she moved kind of fast there. And like I said, with my son, you know, you see the thing on my son. It was probably catching on fire. Doing okay. He said he's having a hard time sleeping. You know, the fact that he woke up, smoked in the house, and he could have died. Yeah, he's back with his mom right now. So now I got another place I can stay at when I go to Toledo.
Yeah? I like this. It's a big book right here.
Nice to meet you. Where do we sign up for?
Thank you. Yes. All right. Please fill out my clipboard if you have not. So you want to be a tattoo artist? All right, so now the 15, right now, I'm going to start drawing. I don't know if you're talking mine. Clean up your lines.
Look at these books.
Yeah. Yeah. That's it. That's where it starts. Because of tattoo designs, they start with clean lines. And I don't have any over here to show you. But if you look at any tattoo designs, it's going to start with the lines and then the shading. So before you can even get to the skin, you have to do that on the paper. So all you're drawing now, so like this, you know, these lines either need to be one continuous line, or they need to be cleaner so that it looks like it's supposed to be. That's only one smooth line right here. There's good sketching before, but you can't do it. You can't have the final artwork be, now you have smooth lines. Of course, I went over it a couple of times. So one, planes, that's it. That's what you need to do. And as soon as you get to that, then you move on to the shading, you know, the light source that you can do. And that's it. Okay. All right. So that's it. That's why he said what he said. That's what it's gonna be first. You want to see her worry about it? You know my wife, I used to forget. Pepper ran. What are you trying to Oh man, you crazy. Just leave it right there. Norman, did Norman leave already?
Yeah, I'm telling you about
trial and error and
Excuse me, beautiful people.
Norman!
Well, I definitely, yeah, I definitely like, you know,
On the website for binders, you can see the schedule.
and they're all free. Okay, the ones that say free. Okay, I'm like a nerd. I'm like a, you know, I'm a nerd. So I do, okay, everybody's on mine. Yes, I sent it. So I don't know. I know I'm kind of shy.
How you doing, man? I'm good, Don't forget to take a card from the attorney.
I never Great. Okay, awesome. Thank you so much. Thank you.
That's right, damn it.
When I come on the 20th, I'm going to bring you a half full book.
Yeah, let me see 10 drawings minimum. Different ones.
Different ones?
Yeah, between now and then.
Okay.
That's 4 weeks, right? You got plenty of time. All right. 6, 28. That's 34. 34 people here.
Got signed yet.
Oh, you didn't sign?
I didn't sign in.
I know I counted at least 40 folks at one time. Whoops. Yeah, still recording.